When you book an Uber, it feels like a simple transaction. But behind the app is a major legal question about work, rights and control. Here's how our CILEX CPQ tuition video breaks it down.
Okay, let's have a look at these tests for employee status, i.e. who actually counts as an employee. Employees are typically defined as people who work under a contract of service, also known as a contract of employment, and whose employers might be vicariously liable for their actions. On the other hand, we have independent contractors who work under contracts for services, and they are usually responsible for their own actions. Let's start with a story that you might already be quite familiar with, as it's quite a famous case. And this is the case of Uber and others against Aslam and others, and it happened in 2021. In this case, a group of Uber drivers challenged the company that ran the app they worked through, i.e. Uber. They were asking the courts to recognise something very specific, that they were workers, not independent contractors. Workers have legal rights, including the right to minimum wage, paid holidays, and protection from unfair treatment. By contrast, independent contractors have very limited rights. They are considered to be in business on their own account, and therefore aren't really entitled to very much at all. Uber claimed that it just provided a platform that connected drivers who were self-employed, i.e. independent contractors, with passengers. Drivers were free to decide when they worked, who they picked up, and how often they logged into the app. So surely this meant that they were running their own businesses as independent contractors. But the drivers argued that in reality they actually didn't have very much freedom at all. Uber were the ones who set the fares, they were the ones who controlled the terms and conditions, and they tracked and rated their drivers, sometimes going so far as to block them from the app if they didn't meet certain performance targets, or to lock them out for a period of time. The case went all of the way to the Supreme Court, and the court ruled in favour of the drivers, with the judges saying that it wasn't enough to look at the written contract or the company's description of the arrangement. Instead, what mattered was the reality of the relationship between Uber and its drivers. That reality, the court decided, showed that the drivers were not truly independent contractors. Instead, they were workers who were part of Uber's business and subject to its control. And this was a really, really big case in vicarious liability. It showed that employers can't just call people self-employed in order to avoid responsibility. Courts are going to look at the reality of the situation. Well, how do they do this? They've evolved a number of tests over time, including the three we're mainly going to look at, being the control test, the organisation test, and the multiple test. Let's start with the control test. And this is the oldest test for employee status. And the basic idea is quite simple. If the employer controls what, how, when and where work is done, the worker is likely to be regarded as an employee. And this really comes from the case of Ewens and Noakes in 1880, where it was said that an employee is someone who is subject to the command of their employer. This case all started when a building owner wanted to claim a tax exemption. He claimed that his premises should qualify for an exemption from certain tax duties, but to do so, the law required that the building be occupied by the owner's servant, i.e. someone who worked for him. The man living in the building was a clerk. He earned a fixed salary, and he carried out his clerical work on the premises. The issue was whether he should legally be regarded as a servant, what we would now call an employee, of the building owner. The issue went to the Court of Appeal, where the lead judge set out what became known as the control test, explaining that a servant is a person who is subject to the command of his master as to the manner in which he shall do his work. In other words, the key question was whether the building owner had the right to control not just what work was done, but how it was done. And the court found that the building owner had no control or influence over how the clerk did his job. He worked independently without instruction or direction from the owner. As there was no master-servant relationship, he couldn't be classed as an employee for the purposes of the tax exemption. And of course, this might seem a bit outdated. Modern jobs often involve skill, judgment, and professional expertise. Employers don't usually hover over every task their staff performs, meaning that for a long time the control test fell out of favour as the sole way of deciding employment status. But it made a really big comeback in the Uber case. In this case, Lord Legat, giving the leading judgment, pointed to several features that showed Uber had a high degree of control over its drivers. Some of these were that the prices were set by Uber, i.e. the drivers couldn't negotiate their fares. Contracts were dictated by Uber for both drivers and for passengers. Job acceptance was restricted, and by declining too many fares, a driver could be logged off of the app for a period of time, for example 10 minutes. Performance was really tightly monitored using a rating system which was used to enforce standards and make dismissal decisions. And there was limited communication with passengers. Drivers were more like agents for Uber than they were independent operators. Based on these facts, the court ruled that Uber drivers were workers, not independent contractors, telling us that control is still a really important factor in the court's decision making, especially where digital platforms are involved.
That was just a small sample of the CILEX CPQ Foundation tuition our students get access to. As you've seen, we take real-world examples, like Uber, and use them to make important legal principles much easier to understand. Across F1 to F6, we have over 58 hours of video content to support you with your studies. Visit the Astranti website to find out more about our foundation course, or sign up for our free F1 to F4 mock exams if you're already studying.